her order was clear. Indirect criminal contempt can be based on non-compliance with an oral order when an individual acknowledges understanding a court order and disobedience of it. So I could have said, I ain't signing a damn thing. And I could have been facing a criminal, indirect criminal contempt, which they can lock you up for, which is how people typically get locked up for child support. They get you for indirect, well, they may call it civil contempt, won't be criminal, unless you say something in court that would rise to a criminal contempt issue. And by the way, you can be held in contempt of court for violating an order when the language of the order is clear and precise and the behavior of the person clearly violates that order. And that's just some information you want to have. Now, as to my case, again, the non-disclosure of a material fact by one party to a transaction may be deemed fraudulent where the other party does not have an equal opportunity to become apprised of that fact. And there you go. And this is some other stuff, but contract settlement issues, this became important. Trial court is not free to rewrite the terms of a settlement agreement, and where the contractual language is clear and ambiguous, courts may not indulge in construction or modification and the express terms of the settlement agreement control. Meaning, whatever's there is what's there. They can't change it. So I'm just giving you some background. So when you all go through your process, it's probably going to be a little similar if the court doesn't do what the law requires them to do. What are you going to do? I hear a lot of people talking about how the law works, but they ain't showing nobody nothing. And what are you willing to do if you don't get it then? How many people are willing to exercise all of their available remedies if you're told no? Because you're probably going to be told no. Now what? Yeah, they may be corrupt. There may be a whole lot of other things. They may be committing all the things you hear on all these videos and shit. What are you going to do about your specific individual case, whether it's child support or otherwise? Oh, and by the way, this would be pretty interesting too. I'm pretty sure y'all probably picked that up. A supposed settlement agreement resulting from mediation cannot be enforced absent the signatures of all parties. And we all saw that. I didn't see State Farm on that release. I didn't see Dr. Shim. I didn't see Shim Spine. I didn't see Shim Medical. I didn't see the United States government through the Department of Veterans Affairs. None of that. So there you go. It's obvious that the stipulation cannot be regarded as binding on those parties that did not agree with its terms. And by the way, the attorney didn't represent all those parties because he never filed a notice of appearance for those parties. And as I go to the mediation information, so this is how I got to where I was. And by the way, when she denied it, she did a blanket denial. But when a trial court grants a motion for sanctions based upon this particular section of a statute, it's required to make detailed, specific findings of bad faith and should recite the facts on which it bases its conclusions, which did not happen for my order, which is why I'm moving to the Court of Appeals. So again, anybody thoughts, comments, questions, whether it's about this or something else? And I know most of you all probably want to see, let me pull up something else. And you want to make sure that you, let's see, 2025, Jordan. What's up, Michael Jordan?
What's going on? I just want to point out that a lot of an issue I've seen and a lot of the case law that I've looked at is that you have to make sure that the case you're going to cite is, well, this is how it is in California. I don't know if it is in other states, but if a case, you can find it on, Google Scholar or other sources like that. But if it's not to be reported, if it's not available to be reported, then
you mean public? It's not a published case, right?
Well, it's still public, and like you can look it up.
No, published.
Published. Yeah. Here it's if it's not published, then you can't cite it directly.
Right.
But what you can do, I heard someone else's recommendation is just cite. You don't have to cite the case, but you can kind of go off the principles that the judges used in the case. But you don't want to just, and especially in the child support space, a lot of the cases are forbidden to be published. But if you read the principles that the judges rely on in those cases, you work them into your motion or your case, right, or whatever. But
Florida's standard is not, because you can talk about the annotated statutes and those kind of things, and that's probably a better place for some people to go. And that's why I recommend people stop being cheap and go find you references that have been cited and used in precedent setting cases, or cases that are I forgot what they call those kind of cases. But it's your resources for grabbing information are very important for that reason.